First of all, we'll talk about a will, last will and testament. Why is it so important to have one? Well, a will gives you the ability to do lots of things. All right, first of all, you get to say who's going to inherit your property. Okay, so you get to choose. If you didn't have a will, the state chooses. They have a specific devise of how property would go. Maybe it might not even be the way we would want it to go. So you get to say where your property goes, who it goes to. Also, you get to say how they receive it. Okay, so if some of your beneficiaries may have some issues with maybe money or maybe a marriage that's not going too well, or perhaps bankruptcy issues, you can actually leave your assets to them in a trust within your will, as opposed to an outright distribution. If you didn't have a will, it would go outright no matter what. There's no possibility of a trust for any kind of protection. Also, in a will, you get to say who is going to administer all those assets upon your death and who will be distributing them. That's called the executor. So you get to choose that. Some states call it the personal representative. We just always say executor. Okay. Also, if you have a will, you get to waive certain requirements that an administrator of an estate, meaning there's no will, would still have to do. So in a will, you can waive the bond requirement, because bond costs money. They would have to get a bond premium and pay that. That just takes money out of the estate. But with a will, you could actually waive the requirement of a bond. You could also waive requirements of filing any kind of inventory. Okay, who wants all of their assets on an inventory online? All right, so you can waive that requirement that the executor go through and list what's all in your estate. Okay, you can also waive the requirement of any kind of filings, like, okay, once you identified all the assets in your estate, where all those assets go. That's called a return. So you get to waive all of that because you're choosing people that you trust to be that executor. So you don't want to have to get them bonded. You trust them already. You don't want them to have to go through an inventory and list everything in your estate that now will be public record. And then you don't want them to have to file returns every year to say, where did those assets go? How did that person get them, et cetera, et cetera. So those are called statutory requirements of an executor. So you get to waive all of those. So that cuts down on the time, the delay, the expense, and again, the public notice of all of those kind of requirements. Also, wills can do some tax planning. If there's some kind of estate tax issues, we could do some high-tech credit shelter trusts and stuff. So again, you could capture some mechanisms that you wouldn't be able to do in an administration if you didn't have a will. So there's all sorts of wonderful tax planning, credit shelter trusts and disclaimer trusts and stuff like that. So those are available if you did a will. So when we talk about a will, what is that? Who's involved in a will? The person that creates the will, you're the testator if you're the male, you're the testatrix if you're the female. So that's one of the parties of a will, is the person who's creating it and saying where they want all their assets to go. I mentioned one already, the executor. That's the person who's then going to follow your direction in your will, get sworn in, first of all, by the court, and then follow your direction, and then distribute those assets. That's your executor. You can also name co-executors. I have a lot of people that want to do that. They want to name their two children as their co-executors, and absolutely, that's allowed by the law. Sometimes it can become a little bit cumbersome because they do have to do everything together. You can't have one co-executor go into the bank and open an estate bank account. But some people, I've had wills with 3 or 4 co-executors. And I'm like, okay. And they're like, well, we won't be here anyways. But that could be quite cumbersome, just logistically, having 3 or 4 people, again, having to go do all of these things. Sometimes they end up declining to serve just because of that reason, that it'll be a little bit more cumbersome. I have a lot of older clients that don't have any family members that could serve as an executor. I have a lot of those. So you can actually name the county administrator, who's a professional. They're an attorney, but they're a professional who is well-versed in how to administer an estate. So we've done that. I don't name a specific person. I just say the county administrator, who is in office at the time, of their death. So that's a possibility. They could even name that if they do have children and they feel like they didn't want to put that burden on the children to have to administer the estate. So again, county administrator can act as your executor. Another important party of a will is your beneficiary. That, of course, is the person who's going to receive the assets that you're talking about leaving at your death. A beneficiary could be anybody. It could be a family member, a relative, a friend. It could be a charity. It could be a church. Okay, I'm sure there's ways to be able to designate your church. So the beneficiary is, again, the person who will take under your will, whatever it is that you've left them. The other party to a will or a probate proceeding is an heir at law. Okay, so the heir at law doesn't have to be your beneficiary, but it's going to be the person that has to be involved in the probate of your will. Okay, people don't realize that your heirs are your spouse and your children. Okay, for example, your biological or legally adopted children. So they may or may not be beneficiaries of your will, but when you go to the probate of the will, they have to be involved in the probate of that because they do have an interest in the purported will, we call that. So heirs at law, and they also come into play if you don't have a will, because they're the ones that would inherit your assets. So when we're probating a will, they all have to get a copy of it because if the will is no good, they're the ones that inherit your assets. So heir at law may or may not be a beneficiary that you've left anything to. Then a will has also important parties at the end of your will, the witnesses. A will has to have two witnesses, two disinterested witnesses. I mean, they're not a beneficiary. Okay, they can't witness a will if they're going to take something under the will. We've seen those before where we've had a will that it has somebody so that they don't qualify as a disinterested witness. Two witnesses are required, okay? A notary public is not required, but since the late 1980s, most wills that you see do have the two witnesses and then a third person, the notary public. The notary signs an affidavit. First, whenever we're probating a will, the first page I go is the back page of the will. Because I want to see, is that affidavit in there? And if it is there, a self-proving affidavit it's called, or an affidavit of due execution, there it is. If I see that, then I know, good, we don't have to find the two witnesses. We've probated wills from the 80s, and they don't have that self-proving affidavit, so we have to try to find those two witnesses. And if you have ever tried to find somebody from that long time ago, it can be very difficult. Yeah. So those are the parties. I call them parties to a will. Okay. Then, so what is required for it to be a valid will? We already mentioned the two witnesses required. Notary's not required. A will must be in writing. Okay. No oral wills are allowed in Georgia. Okay, so must be in writing. The testator or testatrix that I was telling you about have to be at least, how old do you think? You would think 18, you would think 20, 14. A 14-year-old can do a will in Georgia. Yeah, and that's one of the things you're stating in the signing of the will. I am at least 14 years of age. So a 14-year-old can do a will. Also, what's required of a will is testamentary capacity. All right, so that's one of the things the attorney is kind of assessing during two different times. First of all, I'm assessing it when I'm meeting with that person in a consultation to see, do they know who their children are? Do they know generally what their assets are? The children are called the objects of their bounty in the law. Don't know where that comes from. But testamentary means they have to know what it is that they want to do after their death, testamentary with those assets. So a general idea of their assets, specifically, they have to tell me who their children are, and then they have to kind of be able to express what their desire is for a distribution scheme. So testamentary capacity is kind of a low level, but it is at the moment of when they're telling me what's going to be put on that will, but also more importantly, when they come back to sign it. Because you can be very lucid, while you're, formulating these plans, but the test is when they come back to sign. So that's why we have two witnesses and a notary who aren't involved. They have no stake in the game. Believe it or not, they're assessing that person's capacity. So when we have small talk and we talk about the weather or elections or anything relevant, it's not just small talk. We are assessing. And I have called off will signings before if I felt like they didn't have that testamentary capacity. Then the testator must sign the will, okay? However, the signature can be an X, okay? It can be a mark, or it can be the testator directing somebody else to sign the will. I'm actually having one of those coming up recently. She's got tremors and she cannot physically hold the pen or anything. So we're allowed to watch her direct somebody else to sign it. People are blind, obviously, they're not able to sign. So we don't want to not allow them to have a will. So any kind of mark or giving someone a direction in the sight of the witnesses and the notary. All right. And then not only testamentary capacity, but they have to have an intent to convey property after their death. It's very distinct definition. Like a deed. When we sign a deed, you're conveying something right then, immediately. Okay, that's during your lifetime, as opposed to a will, which you're saying, this is going to happen after my death. So again, you're assessing that they're understanding that this is something happening after their death. All right, the things that you can also include in a will, we talked about some of these earlier, but the powers, the statutory powers of an executor. Sometimes the wills just refer to the statute, 53-12-261, so it's a very short part of the will. So you're giving your executor, when they do get appointed, the ability to sell your assets or vote on stock or liquidate this or run a business or rent out property. So powers are very important. That's why when somebody dies with a will from another state, obviously that will didn't give anybody Georgia powers. So that can be a little bit of an issue when we're trying to probate an out-of-state will, but we can talk about that as well. So that's one of the things, again, with an administration, no will, no powers. So you have to get all the heirs to agree to grant the powers to the administrator. Then an advertisement runs for 4 weeks in the newspaper, allowing those powers to be granted. So you're just waiting. It just delays everything. So the estate is unrepresented during those 4 weeks of publication. So that's what a will can do, is actually grant those powers. All right. You can also say in a will compensation for your executors. Sometimes, if it's your children, you go, well, why would I give one child money to be the executor? And then, that's not fair. And I'll say, well, you know what? An executor job is a job that they're taking on. It could be 6 months. It could be a year. It could be even longer if there's real estate involved or out-of-state property. So, we'll talk to them, have that conversation. There is a statutory provision for compensation for an executor. I do tell my clients, though, that the executor can decline that compensation because it is taxable income. So it's not a gift. It's not an inheritance. They have to report it on their taxes. So some executors will waive it and just say, nah, mom wanted me to do this, I'm going to do it. Their expenses are reimbursable, absolutely. They're not expected to use their own money for gas and hotel or something like that if they had to travel. Also in a will, I mentioned a little bit about this, in a will you can make charitable gifts. So again, without a will, it's going to go to your heirs at law. There's no, percentages to churches or colleges or setting up a bequest or an ongoing scholarship or anything. So again, that's another benefit of having a will. If you have a benevolent spirit, then you can put that in there. So I mentioned a little bit earlier what happens if you die without a will. Intestacy statutes determine who gets your property and how they get it, which is outright. Okay. They may have to be posting bond, filing that inventory, those returns. Without a will, they'll eventually have to file a petition for discharge, another filing in the probate court. So again, if you have a will, you can waive all those returns, reports. They don't have to go through annual returns forever and ever and ever and ever. They have to file a discharge with the administration just to stop all of that, even if the returns are saying 0, 0, 0 every year. So that gets expensive and, again, onerous for them to have to do that. All right. And without a will, also, we may not have... we may not know where some heirs are. Anybody have any missing family members that we don't know? We're trying to find some in a probate right now. So we look everywhere. We look on Facebook, whitepages.com, findagrave.com. I mean, there's all these things we have to go through to tell the court what we've done if we can't find an heir. Because those heirs are required, to be given a copy of a will. Or again, if there's no will, they're going to be inheriting something. So again, you can get through all of that of an affidavit of what you did to try to find these people, and then the last step is it can be published in the newspaper for that person. So in our little local newspaper. All right, here's some questions that have come up over the years. People ask me, do I need to file my will with the probate court? While you're alive, you do not have to file it. Okay, there is actually a filing fee for that. Most of them charge $15, but they do have a room in the back of the probate court. Fayette County has an old round filing system or whatever, so they log it in. And some people like that for safekeeping purposes. Some people in assisted living or nursing homes don't want their will to be accessed by anybody that's coming into the room or not. So some people will file their original will with the probate court. And that would be the probate court where you live, in the county where you live. Now, if you move, that will's going to stay right there. So you want to be sure you might go get that will. If you update the will, you got to remember, that other will is with the courthouse. So you just got to be sure that you remember that. But it is helpful because we have had people die without telling family members where their original will is. Okay, we have to find that original will to probate it. So one of the first things we do, we call the probate court, wherever they lived. And sometimes we're lucky that it's on file. Other times it's not, and somebody has to do a search for it. We found them in all sorts of places. Please put your will someplace where your family members, at least your named executor, knows where it is, because we do have to probate the original will. You can probate a copy, but you have to look for that original will first. Do I need a new will if I move out of state? I hear that a lot. Or if I moved from another state to Georgia. Technically, no. Your full faith and credit between the states will recognize a will that's done in another state. But again, there may be some issues because, again, that other state's powers are listed in your will that somebody's trying to probate here in Georgia. So that could cause some delay in getting those Georgia powers to your named executor. Some states don't even allow for bond to be waived in a will. We've seen those before. It's just not allowed in whatever state they're moving from. So here we are, we're, having a requirement for the executor to be bonded. So again, that's money that comes out of the estate. Of course, they have to qualify for a bond, which means they have to be insurable. So, another relatively new thing we have in Georgia, when I talk about beneficiaries, we didn't used to be able to have non-human beneficiaries like pets, animals. We can do pet trusts now, and we do a lot of those. People love their animals. People love their pets. So, usually it's an amount of money to take care of the pets that you own. They have to be in existence at the time of your death, so it's not in perpetuity. But you're setting aside a sum of money to take care of your pets, and then you're going to have a caretaker. You're going to name a caretaker who will physically be able to have them, and then you'll have a trustee who will be in charge of that money. And then you put what all that money can be used for: veterinary care, storing, rehoming, all those wonderful things that we do for our animals. And then you have to say, well, then what happens to that money after the last of those animals have died? I just did one that we signed $50,000 in a pet trust. So, for the cats. So when the last cat dies, if there's still money in that trust, we have to say, where does that money go? And it's going to some humane societies named, etc. But we can do pet trusts now, so just keep that in mind. All right. Another thing you get to also say is those people that you've named in your will, if they're not alive at the time that you die, maybe they died before you or they died with you, then you get to say what happens to their share. Okay, so you're kind of controlling that. Per stirpes means it goes down to their children, which may be your grandchildren. Okay, per capita means not to the kids, it goes to those other beneficiaries that I've named. So again, intestacy without a will, it doesn't matter what your wishes were. So again, you get to say not only who the beneficiaries are, but then, well, if they're not alive, this is what I want to have happen to that share. In a will, you can also state what you would want to have happen with your body. If you want cremation or a military funeral or buried according to my instructions or a green burial. Have you heard of those? Green burials? Those are relatively new. So you can, full military, we've done that before. Honestly, it's the healthcare directive, though, that will be the one document. Your healthcare agent actually is the one who will be able to follow your wishes. The will is going to sit there on the shelf until maybe a few weeks or months later, and then they go, oopsie, do-over. So it really is the healthcare directive that has 3 post-death powers. So that's really the one that's going to allow your healthcare agent to follow your wishes. Although we do put it in the will, a lot of people want that to be in print, that they wanted the ashes spread over Red Top Mountain. That was one of mine. We have a lot of burials at sea. We have a lot of military, so we do put it in the will just because they want to make sure. All right, we do have one that we've added relatively recently. Executor can have access to your medical records. We put that in probably about 10 years ago in our wills. You're dead. You're the patient. You're dead. But your executor may need to get your medical records. So we want to give a HIPAA release to your executor. That could be for insurance purposes, making claims for life insurance, medical insurance. It could be for lawsuit purposes. Maybe there's a wrongful death involved or medical malpractice. So we put that in our wills that the executor has the HIPAA release to be able to get your medical records, because that person, your executor, may not be the same as your healthcare directive. So, all right. You can also say, believe it or not, in a will, if you and your spouse die together simultaneously, if you were in a car accident together, in our wills, we just say, in that event, then my spouse will be deemed to have survived. So we're picking the order of death. So that says, okay, this will is probated first. Well, it doesn't have to be probated. Everything flowed into her. So it's really his will that will be the actual probated will. So kind of interesting that we can do that. We don't want to wait 6 weeks for the medical determination of who of the two died first, who died second. It doesn't really matter if the wills are identical. We want them to go to the people that they wanted, and we want an executor as soon as possible. All right, so here's an interesting one. You can also put what we call a no contest clause in your will, or an interorum clause, or a contest clause. I've seen all 3 of them. They're the same thing. If any beneficiary that you named in your will doesn't like what you did, and they said, nope, I wasn't supposed to get a third, I was supposed to get it all. Okay, so they're going to file a complaint. They're going to contest that will. They're going to say, you were crazy, you didn't know what you were doing, somebody was influencing you. Well, that's a contest, and if that's the case, everything stops. Nobody can get any distributions because the executor now has to defend your will. So what you're saying in your no contest clause is that if any beneficiary contests the will or any part of the will, and then they lose that contest, not only do they lose the contest, they don't get anything from my will. So if I left them a third, they don't even get a third. So a lot of people like to see that in there. So we put it in there. Most of them have that in there. So that's my spiel about the wills. I can answer some questions if I didn't answer them already. I know we have microphone people.
I wanted to ask, you said that we can have handwritten wills in the state of Georgia.
Mm-hmm, mm-hmm.
Do you have to have two witnesses?
Yes, absolutely.
You do.
Yep.
Okay.
Yep.
And
still have to have that.
one more question. The wills that you do at your office, do you guys keep a copy? Does the attorney keep the copy?
We do. We scan them as a PDF file. We don't keep any physical copies, but we also have a little letter that takes us off the hook that if for some reason we don't have that scanned copy, please don't rely on us having that. You'll leave with the actual will and a copy of the will.
So if they can't find the will, they can still come to you.
But we get those calls, and then we make those calls as well, because that's one of the second call after we call the probate court is we call any attorneys that they see in a check register or something that may have done legal work for them before. So we will call any other attorneys. We put it on the Bar Association websites if they're in Fayette. We do that, or neighboring counties. So we'll ask, has anybody ever prepared a will for this person? Okay. So yeah, that's you have to do an affidavit of diligent search when you have a probate of a copy of a will. So those are all the things we put in there that's what we did for the client.
I don't mean to take up all your time,
That's all right.
But what is green?
Oh, the green burial? Oh, okay. Okay, there are very few places that do that, but my understanding is it's really natural. They just wrap your body in gauze, and that's it. She said it. You're basically being composted. Yeah, I think there's a monastery that does it. Conyers Monastery. That's what it is. Yeah.
I have my spouse has passed, and both of my children. Okay, I have 6 grandchildren by my youngest son, but they all live in different families dynamics now. So what I have, I want to go to them, but they're all underage.
Okay, that's a good point. So in your will, you would put what's called a testamentary trust, because it's in the last will and testament, because we can't give money to a 2-year-old or a 4-year-old or whatever. So you would actually put a testamentary trust for any beneficiary under the age of, and then you say what that age is. 18 is majority, 21, 25. So you're saying, I know that this person can't receive the money, so I want it to go into a subtrust for that beneficiary until they reach the age of, and again, you get to determine that. And then there would be a trustee of that money in charge of that. So again, unlike when you don't have a will, that's not an option. But yeah, absolutely, with a will, you would do a subtrust for any beneficiary under the age of. And then you would put somebody as the trustee of that money. Okay.
My name is Bonnie.
Hi, Bonnie.
I have a neighbor that I have been taking care of, known him for 30 years, my husband and I have, and he has prostate cancer.
Oh, goodness.
They have given him until December now, 6 months to live. He has surpassed the date the doctor has given him, which God knows when you're going to die, but he does not have a will. He has no family. He has no children. He has no one. He has not made out a will yet. And, of course, I will tell him that if he doesn't, then the state will take over.
Well,
and they will make
the state will determine, that's right, through the intestacy statutes, who gets. Now, here's an important distinction, though. You can set up your assets, and he could too, beneficiary directed. where he could, like on a bank account or life insurance or 401k, he could set up beneficiaries of who he might want those assets to go to, so a will wouldn't be needed.
Right.
Yeah.
Okay.
Now, if he owns real estate, that's a little bit harder to do, but the law requires that somebody be found in this family tree of his, spouse, children, go up to parents, out to siblings, children of, great aunts, great uncle. I mean, there's a specific scheme that they will find somebody,
Right.
and that may not have been the person at all that he would have ever wanted to inherit those things. So.
Well, he's an animal lover. He gives to St. Jude. He
Yeah.
also gives to Wounded Warriors.
Oh.
So he has those things, but without a will, that they won't even get anything.
That's right. That wouldn't go to them. That's right.
So he would need to, he's very alert, nothing wrong with his mind.
That's good. Testamentary
So
capacity.
I'm here tonight to try to get information for him
Yeah.
so he can do what he needs to do or what he wants to do.
That would
So-
be good. And then, of course, the important part is naming an executor who would follow all of those wishes. So, very
All right,
good.
thank you very much.
You're welcome.
Can a person do their own probate, or do they have to go through an attorney?
They do not have to go through an attorney. No, that's pro se. So for probating a will, absolutely pro se. The forms are on Georgia probate forms. Just Google that. They have there's 73 or something different forms, but not all of them deal with death. Branding of cattle, firework display. I mean, there's some weird ones out there. But Georgia probate forms. So absolutely, you don't have to have an attorney. That's good.
I'm Linda. And right here, does every will have to go through probate?
That's a good question. Not necessarily.
Because when my husband died, I didn't go through probate.
Okay, that's a good point, because probably all your assets were joint together, or he had assets that were beneficiary directed to you. Maybe he had them TOD, transfer on death. Maybe your house was joint tenants with right of survivorship. So it's very common for, at the death of the first spouse, that a probate may not be needed,
Yeah, 'cause
just
we
for that
lived in
reason.
Washington State, and we had a community property agreement.
Okay, there you go too. We're not a community property state in Georgia, but a lot of those do have that. So good point. Yeah, you have a will, but you don't know that it may not have to even be probated. Now, at the second death, we may lose all of those joint ownerships, beneficiary directed, and that may be when the probate comes in, is at the death of the second one.
But I would probably have, my heirs would probably have to go through probate with me.
Yeah, unless you go through all your assets and put, beneficiaries on them, bank accounts, brokerage accounts, IRAs, 401ks, if you have all of your life insurance, beneficiaries.
Yeah, they all have named beneficiaries.
There you go. So it's really a matter of all the assets that you have at the time of your death. The more difficult one would be a house, real property or something.
Say something, would now be a right time to say something about how you have your estate set up, what passes under the will and outside the will?
Okay, that's a good idea. Yeah, it's all about titling. It's when we talk about whether a probate is needed or not, or a will has to be probated or not, it's all about how those assets are titled. Joint right of survivorship is usually, you look at your deed when you go home. Okay. Joint tenants with right of survivorship means if there's two of you, when one of you dies, it's automatically the others. Bank accounts, usually joint right of survivorship. So if one spouse dies, it's automatically the others. The bank doesn't even make you take the spouse's name off for a while. If you have a lot of assets that are beneficiary directed that you can't have joint, like a life insurance policy or a retirement account, you can't add a spouse onto that, but you can be sure to have beneficiaries. So go home and just make a list of all your assets and see what you can do to not have to have that asset go through the probate process. Now, here's a common question I have all the time. Well, I'll just add my kids to my bank account. And then we say, okay, let's talk about that. That's good, but then it could be bad. So just be aware of that, because you're exposing that asset to the risk of the person that you're adding on. So sometimes that's not always a good idea, but usually spouses, again, usually you're on those accounts together. But when you're adding children or something, you might think about more so as the beneficiary, I would say. Payable on death, transfer on death would be good. A way to avoid the probate process.
Hey, how you doing?
Good.
My name is Kimberly.
Hey, Kimberly.
And thank you for coming and talking with us.
Well, thank you.
I have a couple of questions, so just please bear with
Sure.
me. We have a situation where my mother died. She was in the state of Florida.
Okay.
So I'm sure it's probably a little different. I have a couple of questions. Which one? It says, first of all, it's 6 of us, the children. And we had one of the brothers tell us that during before my mother died, maybe a couple of days before, he said that he was the power of attorney.
Okay.
And we didn't have a problem with that
Okay.
because that's what he said he was. Then he, after my mom died, he said that he's the executor.
He's the executor, okay, of her will.
And there was no problem with that.
Okay.
We're just like, okay, now it's time, you need to show us, because he's not helping us. He's
Right,
not discussing anything with us. And
well, there's good news about that. First of all, the powers of attorney die with the principal. It's immediately ineffective. The agent can't be taking that to the bank, to get access to those funds because you're not the agent. It immediately extinguishes at the death of the principal. So he's no longer the agent when the principal dies. And to get somebody appointed as an executor, I'm not familiar with Florida, but everybody I know tries to avoid probate in Florida for different reasons. To get an executor appointed, all heirs at law have to be notified. So if he's executor, he may be the nominated executor in her will, but he's not the appointed executor without you all knowing about that.
absolutely.
Because you all get a copy of the petition.
Yes.
And that's one of the things you're able to see is a copy of the will, who's actually nominated in the will.
Right.
And then you get to file an objection if you have an objection to the will, if you thought it was done really close to death, maybe it was not done with testamentary capacity. And then you also get to look at the person who's nominated, if there's any reason why you think they shouldn't be the executor. Maybe there's
Absolutely.
some, reason not
Yes.
to.
Let me read these questions. It says, if you have a special corporate warranty deed with a single woman and a married man as joint tenants with right of survivorship, is a signature from both parties required?
To do what? To convey it or?
To make it binding.
So a deed, I think we're talking about a deed. So a deed comes from a grantor to a grantee. So a grantor, if they're both joint tenants with right of survivorship, they both have to be involved in the conveyance. If it's tenants in common, they can each convey their 1/2 interest. Right. But joint right of survivorship, they have to both be involved. There's no undivided interest that they can convey to anybody without both of them being involved. But yeah, and that's grantor or grantee.
Okay, I'm sorry. It says, does the title of deed need to be updated before a descendant dies or after the person dies? Or who's responsible for the update of the title?
Okay, so if the deed is in a person's name and that person has died, if there's no joint tenant on there, okay, the buck stops with that person. It just comes to a standstill. So that's where an executor would have to be appointed for a will to be able to now say, what does the will say, where that all those assets go, the house included. So nobody can convey it, nobody can sell it, nobody can borrow against it. It's now a deed that has nobody, it's unrepresented. So that's where the executor comes in to read the will to see where any of the assets, including the house, would go.
Okay, I'm sorry. And another one. My mother, she did it's called a revocable trust.
Yep.
According to a revocable trust, which is now irrevocable after the descendant has passed away. I I don't know how that
Okay,
that
I
works.
can talk
you
about
help me?
that. That was my next on my list, but I was
Okay,
going to
sorry.
skip over it if we had to go to financial powers of attorney.
sorry.
So a revocable trust sometimes is called a will substitute. Okay, I am a very visual person, so I think of a revocable trust as a flower vase that you create while you're alive. It's glass, it's see-through, because we look through that flower vase and we see you. It's still you, it's still your social security number. Nothing has changed. It's not a taxable event. So it's glass, it's see-through, but a flower vase needs flowers in it. So the goal of a trust is to put your flowers in the flower vase while you're alive. Your house is a flower, your brokerage account is a flower, your car, your personal property, bank accounts. The idea is to get all those flowers in there before you die. And then when you do die, it does become irrevocable, okay, because you can't change it anymore. And then your trustee just reads the trust document and starts distributing the flowers. Without going to the probate process, without going to the court, taking the oath, without publishing in the newspaper, without finding the heirs, etc. So a trust avoids the probate process if it's fully funded. Trust is private. We can't go to Georgia probate records and see the copy of a trust, but you can see a copy of anybody's will. If you want to see what anybody did, just Google Georgia probate records and put in the county. It's all right there. It's the petition to probate the will, everybody's address, what everybody's signature looks like, a lot of public information. So trust avoids the probate process. It's a private document. It's not public record. Trust is good for incapacity planning. You are the trustee of this flower vase. You're in charge of these flowers. But if you become incapacitated, there's a disability trustee who slips into place, not through a financial power of attorney, not through a court appointment. They are in the document to come in and manage those flowers for your benefit. Will can't do that. A will is just waiting for you to die. And then the fourth benefit of a trust, if you own any property outside the state of Georgia, you got a flower down there in Florida, or a cabin flower in North Carolina, whatever, Alabama. We have a lot of Alabama lake houses. Those flowers can be brought into your Georgia vase, and then you're not going through two probates, or your family's not going through two probates, called a Georgia domiciliary probate, and then the ancillary probate wherever that flower is located. So some people like that, and they do those revocable trusts.
And I have one more, I promise you.
She said it, one more.
It said, listen, what happens if you realize that when you saw your mother's signature, that it's not her signature?
Okay.
And this signature is in several places the exact same way. It's misspelled. It's not even her writing. And my mother was very capable of writing her signature the day.
Well, then that's a good point. You're talking forgery. But the fact that you weren't there whenever that was done, because I know my signature's been on documents for 21 years now, and if I looked back 21 years ago, I did a lot different signature than I do right now. And even on different days, my signature can look different. So, and if it was a document that was witnessed or notarized, then you got other people involved in the potential forgery of that. So all of that kind of raises issues. Look at who was also on that document along with that signature. Did somebody else attest to the fact that was her signing it? Remember, a mark, can be made. People can sign for other people at their direction. So, but look at the surrounding circumstances of it too.
Yes, I have a question. Oh. Does a will have to be ratified? And if it does, what does it mean to ratify a will?
I've never heard that term before, but you might mean probated.
Okay.
Probate. Probate, it does not have to be probated unless there's some assets that have hit a brick wall. Like if there's like we were talking about the house that now has somebody's name on it and they've died. So it may be that now we've got to probate that will to have that house go wherever it needs to go. So the only requirement of a will after somebody dies is to file it. Okay, a lot of people didn't know that. You must file the original of a decedent's will in the probate court wherever they did die. Okay, within a reasonable period of time, which is undefined. The idea is if the will ever needs to be probated, everybody will know where it should be. You know, they can call the probate court, and that's where it should be. So otherwise, it's stuck in a drawer somewhere in a little dresser that got shipped off to North Carolina, and they finally found it when the person that bought the dresser pulled out the drawer, and there was the will. So that's the idea, you must file it with the probate court, but not probate it. There's no requirement to probate a will. It all goes back to those assets and how they were titled. That determines if a will has to be probated, because you got an asset that's not going anywhere, and you don't want that turned over to... No, we were just talking about that. You can do pro se filings, absolutely. They have a form, you know, or the part of the form has your name, and if there's no attorney, it's just blank. Absolutely.
Hi, I have a question. Hi, thank you for coming. My name is Faith. So my father passed away of brain cancer many, many years ago, but he had a will, and he had 5 stepchildren, and then me and my sister, which is his children, his birth children.
Got it.
And in that will, when he passed, everything was to go to my stepmother.
Okay.
And everything did.
Okay.
But in the will, it said that she was to distribute among the 7 children.
When? After her death?
Upon her death.
Oh, see, that's the risk.
It was a risk because I never seen any of the property or any.
Right.
Me and my sister, we saw nothing.
Because you're not related to the stepmother, so when she dies, you don't get notice of that filing of her will. Just her 5 children do.
Right.
So here's the risk, if you will, and I love you will that says, hey, upon my death, everything goes to my spouse. And then you say, but if my spouse doesn't survive me, then it goes to my two children. Well, if the spouse survives and everything goes outright to her, that's the end of the story. She can do whatever she wants with it, even if she had a will that said, oh, I'm going to split it all 7 ways. But she can go take that will of hers, tear it up, as long as she has capacity, go do a new will, and then you two are cut out of it. The only way he could have prevented that is if he left everything in a trust to her, and then the trust is irrevocable, and upon her death it goes 7 ways. But if it's an outright will, she can change it. She doesn't have to. You don't even get a notice of it probating.
And I didn't consult an attorney because I didn't think I had any ground to stand on. But I've never asked the question. I've always wondered about it.
Yeah.
So
if his will left it outright to her, and you would have gotten a copy of his will because you're an heir, see, along with her because she was a spouse. So you see the will and you see it's going outright to her. After that, assets are in her. It's in her court, like they say. You've been dying to ask a question. I'll repeat it if I have to. Okay.
Thank you, and thank you so much for being here. I did want to ask, with the will being filed in a quote-unquote reasonable time.
Yes.
What in Georgia is considered a reasonable time?
That's a good question. It's never been defined.
Okay.
Yeah, because I have widows come to me and they're like, I never filed his will.
Yeah.
And I'm like,
well, reasonable to you is not the same as
right. So then I say, well, the police were looking for you. I mean, now I know where you are to have to report it.
Right.
No, there's no and the only reason it would come up is if there were somebody looking to probate it, an after found asset, something like that. That's the reason to lodge it. They call that lodging it in one place. So again, it's, if it never had to be probated, it may not be an issue at all. But the law just says within a reasonable period of time. So if we know of it, we say, hey, we'll do that for you. We have a little cover letter pursuant to OCGA statute. They are hereby filing but not probating this will. And then we get a copy of it back as filed. And then we give that to the person. But again, no sanctions, no nothing like that, just reasonable period of time.
Hi, my name is Annie Guffey.
Hey.
Nice to meet you. Glad you're here. I had a brother to pass back in March of this year, and he did not have a will, but he has like land and a mobile home.
Okay.
Now, by mouth, he told us he wanted his daughters, which are not anywhere on record that these are his children, to have.
That's the other problem.
property.
That's right.
So I guess my thing is, because I am the next of kin, I want to know what steps should I take to find out about this land, because I don't think he has nobody name on there,
Just his name.
just his name,
Mm-hmm.
and like I said,
Well-
no will at all.
Well, you can step up and petition to be the administrator of his estate if nothing's happened with that land. So you could petition to be the administrator of his estate, but you'll have to do an heir determination worksheet to lay out to the court, who are the biological. And if the girls are not biological or legally adopted, you're going to be saying under oath on your petition to be appointed administrator. If you're saying that you are the one heir at law, parents are deceased, he has no spouse, he has no biological or legally adopted children, that might be one way that you could start the ball rolling, is to petition to be the administrator of his estate. Where did he die? What state? In Georgia? Yeah. Yeah, so the county where he died would be the jurisdiction, and you could file a petition for letters of administration, and then again, you have the power to deal with that property and the mobile home on it as administrator. But in that petition, it's called a verified petition, you're swearing that he had no other heirs except for you. But then you would have to know that you're truthfully, saying that. If he said they were his daughters, you'd have to kind of investigate further if you felt like.
Well, my investigation, I already know a lot about his history because we always talked about it.
Okay.
But by word of mouth, this is what he said.
Right.
That these are, because one of them I know is no relation at all. She just, he helped raised her with her mother at one time in his life. And the other one is sort of questionable, but she is our niece. So I'm just trying to find out to keep it from the family, whatever happened to it.
Right.
Just trying to find out what would be my step if I decide to step in.
I would start with looking at that petition for letters of administration. It's online, like I was talking about, Georgia probate forms. Instructions are on the first couple of pages of it. And that would at least give you some standing, as the administrator of the estate to take control of that land so it doesn't just dissipate or, squatters or adverse possession, all sorts of terrible things could happen as the time goes by.
Okay. Thank you so much.
Should I go on to powers of attorney?
Well, actually,
healthcare?
that's where I was going to
okay.
kind of shift the conversation to for a minute.
Sure.
So James and I guess maybe a 1-2 part question, I'm not sure. So in 2012, we had our wills done. Along with that will, we had durable power of attorney completed.
Yep.
Healthcare surrogate, a living will, and our HIPAA release done.
Okay.
As well.
Okay.
So that's 2011, 2012.
Okay, got it.
2019, and that was in Florida.
Okay, so there's still the documents.
2019,
Yep.
we had our wills updated when we moved to Alabama.
Oh, Alabama. Okay.
Only the will. We did nothing with the power of attorney, the HIPAA, the healthcare surrogate, and the living will. My question, I know, right? Like, get it out. All of these documents, the living will, and then all of the healthcare stuff with the power of attorney, all of those documents are completely separate, because I'm wondering, should we have updated, when we updated our will in 2019, should we have updated all the other stuff, or is all the other stuff still considered valid, although it was done in Florida?
It's still all valid until you revoke them and do a new document. So you may still have documents from Florida right now that are still in effect. Financial power of attorney, healthcare, living will, et cetera. You may now have an Alabama will, and here you are in Georgia. So
I'm gonna come see you. I'm gonna make an appointment anyway.
But at least you have documents.
But I'm just trying to make sure until we get there. Make sure nothing happens.
Yeah, your Florida, documents are still valid because you haven't revoked them, with a subsequent
Other
document.
than that will, that Florida will is, since I have a new Alabama will.
Yeah, the Florida will, Alabama will revoke the Florida will.
Gotcha.
That one's no good. But now if you're going to plant your feet in Georgia, as residents, then it may be good, because those are state-specific documents. There's not a national, power of attorney, not a national healthcare. But that doesn't mean they won't be recognized in Georgia. It's just not going to have the Georgia reference to the powers, and we don't do living wills in Georgia anymore since 2007. The Georgia legislature, they'll recognize one that was done before 2007 in Georgia. We just now have an advanced directive for healthcare in Georgia that combines the living will and the power of attorney for healthcare into one document. So July 1st of 2007, that's when Georgia, at least,
Okay,
did
so
away
till I
with
get
them.
an appointment, we okay right now?
Yes, you okay. That's right. You got a will and a financial and a healthcare. That's right.
I'm not sure if we're going to go into it, but we have a will, don't have a trust.
Yeah, that's all right.
Is it okay to, one, update the will, then create the trust to put the will into?
Okay, that's a good idea. Okay, so you don't have to have a trust. You don't have to have a trust. The only reason people do trust is maybe for one of those 4 reasons, or all of the 4 reasons I was talking about. If you do a trust with the flower vase, you do what's called a pour-over will. Okay, it's called a companion will or a pour-over will. In my little illustration of my flower vase, think of that as a pitcher of water. Okay, those assets in that pitcher are going to go through the probate process. Then they just pour right into that flower vase. And then the flower vase tells where they all go. So the pour-over will just says to the public out there, hey, all the assets that I own go to my trust. So nobody knows anything. So it is a will with a trust, but you can have a will and not have a trust. You may not need a trust. Or you may have all your assets right now joint, beneficiary directed, and so the will may not even have to be probated at the death of the first one of you, too.
Okay, so you mentioned real estate. That's complicated, so it should be in a will and trust?
Well, usually with spouses, usually those deeds are joint tenant with right of survivorship, so that has to be typed in the deed itself. So look at your deeds, the 2 of you as joint tenants with right of survivorship. The other way couples can own property is tenants in common. That you will not see typed in the deed. Okay? It's assumed it's tenants in common unless it specifically says joint tenants with right of survivorship. Tenants in common means you each own a half of the whole. If one of you dies, that half is out there floating around going, where do I go? Where do I go? And it has to go through a probate process to get to the other half of the owner of the house. So that person now owns the whole ball of wax.
And just for clarity, for example, my mother has 2 homes, one in Florida, one in Georgia, and I don't think my sister co-signed on the one in Georgia, but the one in Florida, nobody's on. So me and my brother are trying to get on that deed through maybe a quick claim or warranty deed.
Okay.
So that we could have some form of access if she passes away. Is that, you mentioned, I'm just making sure I'm clear that the trust is only to avoid some probate stuff. Do you have to have the will, or one or the other, or do you have to have the will? Like, can you just have a trust? If I was today, my mother doesn't have anything but the 2 homes.
Does she live in Georgia?
She lives in Georgia.
Okay, so she still owns property in Florida,
Yes.
but her residence is in Georgia. So if she dies, it'll be probated in Georgia. So yeah, she can add you guys to the property in Florida, but you might want to look at the gifting ramifications of that, because she's essentially gifting you an interest in that property while she's alive. So there's all sorts of basis issues. There's gifting of over the annual gift tax exclusion amount. There's liability. Remember, adding somebody onto a deed exposes that asset to the risk of all of the owners. So I'll pick on your brother. If your brother goes and has a car accident, kills somebody, there could be a huge judgment, and all of a sudden that Florida property is searched, or disclosed in the financial disclosure statement, and that whole Florida house could be at risk of somebody, of one of those owners, liability. So usually what happens, the Georgia resident, your mom, creates a Georgia trust, and then she has an attorney in Florida deed that house into her Georgia flower vase, and then puts the Georgia house maybe into the flower vase as well. So that would kind of accomplish what you were talking about without exposing that other property to owners' risk, divorces, litigation, stuff like that, liens, garnishments, or whatever. So, now that's a different one altogether. That's, yeah. It's very difficult, yeah, because you're talking about a lot of potential owners of a piece of property because it all went down. Yeah, that's very difficult. There's a whole part of law about that. Now that I'm not sure. I'm not a divorce attorney, so I know they have certain parameters about that. So I would have to not answer that question just for that reason, because I wouldn't never do divorces. I like to sleep at night. So.
We do thank you for coming so much. You've answered a lot of questions and given a lot of information that a lot of us need to hear. My husband and I established a trust in 2002, a living trust.
Okay, yep.
However, we've never put any flowers in that vase.
Okay, all right.
And
well, you're still alive.
Yeah, you're right.
Yeah.
And we don't want to. We don't want that trust anymore.
Okay.
So
it's empty.
It's empty.
So don't fund it.
So we have already got another will because the will was in it, the pour over will,
That's good.
And all that kind of stuff.
See, you already know the answer to your question. That's good.
I wanted to know, this thick binder I have, fodder, throw it away, what do I do with it?
Use it as a doorstop to prop
big.
open the door.
It is
They're
too
very
big.
thick.
Right.
Yeah.
Well, there's another thing. It still has to do with the trust. My brother-in-law died in 2022, and he had a trust with the same firm. He never put any flowers in his trust either.
Okay.
So we are finally, because there was some disputable, what do you call it? Land. I don't know exactly how to say it. His mother had also had the trust, and she had put some things in the vase. But nonetheless, her will said that upon her death, that the land would, instead of being, would be divided between, 4 heirs.
Okay.
One of those being children of one of the sons. So it actually went 6 ways.
Okay.
Okay. So, and then at the passing of any of the other heirs, it would go back into the pot and be divided with the 3 surviving families. Okay, so with his trust, the firm that was handling it said that a quarter of the land belonged to him, and so this put us in a bind. We had to get a declaratory judgment of the land, who did it belong to?
Yeah.
And the court said it belonged to the children, that it didn't belong in the trust, because the trust was never funded with that.
Okay.
So, and we've just gotten that straightened out. And now we're able to finish his living trust and make all the my husband is the executor, and everything is, taken care of. But I really wanted to know this. There's no need in hanging on to that book, is there?
If it was his trust or your trust? Was it your trust that you were talking about first?
Yeah.
Yeah, if
our
it's your
trust.
trust and there's nothing in it and you've
Right.
done a new will,
We have.
that's right, because the pour over will would have put stuff right back into that vase after you die.
Right.
So if you've done a new will, that revoked all prior wills.
Okay.
So now you have a new will that's not going to direct it into your flower vase, and you have an unfunded trust. You didn't leave anything in there. So just shred it or burn it.
Okay.
There's no tax ID number for it,
No.
so there's nothing like that.
Nothing
It
like
was
that.
your social. So yeah, I would just destroy it so that nobody would think that it was still a valid trust.
Right.